Welcome to part 2 of How Do I Get a Guardianship or Conservatorship? We'll cover some common questions. Please watch part 1 if you'd like to hear more about the process to establish a guardianship or conservatorship in court. How long does the process typically take? If the case is uncontested, it usually takes about 2 to 3 months. If the case is contested, well, it takes longer. The respondent has a right to request a trial, and you'll have to get that on the calendar. Sometimes there's an option for immediate relief for imminent concerns while you're waiting for final resolution. Do you need an attorney? Well, it's a pretty rule and procedure heavy process. It's not particularly difficult, but there are a lot of moving parts and tight timelines. So it's possible, but it could be challenging for anyone, even lawyers who don't do this all the time. It's an area with small and big changes, so your practitioner should be up to date, especially if this is a time-sensitive matter. So if you choose to do this yourself, the forms are on the state and county websites. I wish there were more easy to follow resources for regular folks. Here is a snip of the Washington State database with the forms. Choose Word if there's any possibility you'll work with an attorney so they don't have to reinvent the wheel. Here's a snip from the county database for local forms. These are needed to set the hearing before the judge or commissioner. Again, there are some limited instructions that can be found on the websites. Can anyone become the guardian or conservator? It's not a sure thing. Nothing involving court is. The nominee completes and files a disclosure form with their background. Always consult with your attorney about any history so he or she isn't surprised. It's not a good look if the investigator or court brings something up and your attorney is caught flat-footed. Another consideration is whether the nominee is bondable. If there is limited income and negligible assets, this isn't really an issue. But if there's money, the liquid assets need to be bonded, blocked, or both. A conservator who can't be bonded lacks flexibility to access funds in an efficient way. Do you need to attend hearings? At the initial appointment, I'd say yes, especially since many hearings are over video Zoom. Sometimes you have to go in person, though, to get your certified order and letters of office more quickly. After that, there are routine reports and other possible hearings before the court. Some of these can be handled offline in a process called ex parte via the clerk, and others are due a live appearance, usually by Zoom these days. Court hearings can be scarce, and sometimes you have to wait weeks or months to get a slot that works for all parties. How much will it cost? This depends, of course. Some attorneys will offer a flat fee, and some will charge hourly. The time involved will depend on how contested the case is. Is everyone in agreement? Are there multiple people competing for the same role? Does someone object to you? Also, how tech-savvy are you, and how much time will the attorney need to expend just getting documents for review and signature? The amount of fees also depends on whether this is county pay or private pay. There are two tracks. County pay means that the respondent, that's the individual who needs the protection, has less than $3,000 to his or her name. The county will pay the court visitor and the attorney for the respondent for their time. Private pay means that the respondent has more than $3,000. In this case, the court visitor and the attorney are paid at a higher rate by the respondent. These fees can really add up and consume a smaller estate. Who pays? Usually the respondent does, or more like it, the future conservator pays for all the fees from the respondent's estate once he or she gets access. Sometimes a family member pays for everything as a volunteer. Sometimes the petitioner is the hospital and they're willing to pay the fees. More rarely, the court assigns payment to someone else. Are there risks if you file for guardianship or conservatorship? Yes. Court always involves risks and unknowns. There are no guarantees. The petition must be filed in good faith, or you can get stuck with paying all the bills potentially. Hopefully your attorney can help you make this determination upfront before taking any steps. Another risk is that you spend all this time and money and the court orders a less restrictive alternative like a power of attorney. The court could also surprise you by appointing someone other than you. It could be another person who the court thinks is a better choice, or the choice of the respondent. Or it could even appoint a professional guardian you didn't get to pick or agree to. Are there alternatives? Yes, a power of attorney is a first choice and should be considered before embarking on a guardianship or conservatorship petition. See my other video, Guardianship or Power of Attorney, which one is better? Well, that's a lot to think about. As per usual, consult with an attorney in your jurisdiction for advice specific to your situation. Thank you for watching this presentation of how to get a guardianship or conservatorship questions and answers, and let us know if we can help.